Morning is People of the State of Michigan versus Sandra Gale Bottoms. This is case number 25-14108 FH. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Jeff Harrison here on behalf of,
She's next to me at the table.
Thank you. We are here today on this case for a final pretrial. That was conducted a little while ago this morning between myself and counsel in chambers. Counsel informed me that they intend to enter a pretrial agreement in this case. I understand it's going to be a no contest plea. I've already reviewed an exhibit. I'm just going to hand that to the court recorder and have her please add an exhibit sticker. In the meantime, Mr. Carnes, why don't you go ahead and tell me the terms of that pretrial agreement, sir?
Your Honor, it's my understanding the defendant will plead no contest as charged. The reason for the no contest plea being potential civil liability.
that is my understanding as well, Your Honor.
All right, thank you very much. Thank you, Nancy. Ms. Bottoms, I'm told today that you're going to enter what's called a no contest plea today on the record. It's important that I tell you what the difference is between a no contest plea and a guilty plea. In a guilty plea, the defendant must state on the record what their actions were that caused them to be guilty of the offense. However, the court can take what's called a no contest plea. In a no contest plea, instead of requiring the defendant to recite a factual basis, the court is going to look at an exhibit that the parties will stipulate the court can look at. And then I will determine guilt based upon that. Now, a no contest plea can be given by a defendant instead of that guilty plea in a couple situations. One of them is when there is potential civil liability. Civil liability means that the other party or the alleged victim in this case could sue you. And then there are other steps. If they got a judgment against you, they can go against you, any assets, other things to try to recoup that money. In a criminal case, it works a little bit differently, but that's the difference between a no contest plea and a guilty plea. Do you have any questions about that, ma'am? Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Do you need me to repeat anything about that guilty plea, no contest plea that I just talked about? All right, thank you, ma'am. Well, today I'm told, I'm sorry, I know here in this file, you're charged on what's called a felony information, which is just a piece of paper, and it charges you with a single count. Now on that, it charges you with embezzlement by an agent or trustee. Embezzlement means somebody takes from somebody over whom they have either an employee relationship or a fiduciary or agent or trustee relationship, kind of like a business, a club, or so forth. So in this file, an embezzlement comes in different levels based upon the amount that's allegedly was taken. In this particular file, it's alleged that you took between a minimum of $20,000 or more, but less than $50,000, and that is a felony. Now that's a felony punishable by up to 10 years and/or up to $15,000, or 3 times the amount that was embezzled. Now, there aren't any other allegations here involving any other nonprofits, is there, Mr.
No.
That's an important question for me to ask out loud, Ms. Bottoms, because there can be what's called consecutive sentencing if there are other convictions for similar conduct involving taking from a nonprofit. But I'm being told that there aren't any other allegations out there involving any other nonprofits. Consecutive sentencing is important to understand because sentences can either be run concurrent, which means at the same time. Let's say a person were convicted of 3 offenses at the same time, they would run concurrent, which means every day served is a day off of each sentence. Consecutive means that they can be stacked on top of each other. So let's say in a case like this, a person were convicted and the judge gave him 2 years, then they were convicted a second time, or they could get another 2 years, so they'd serve those. Consecutive means a total of 4 years. But in this instance, we're just looking at, well, there isn't any other charge, so it doesn't matter. So again, the charge of embezzlement by an agent or trustee. The allegation is that you're an agent or trustee of the Club Cadillac and that you took from them at least $20,000 or more, but less than $50,000. And again, that's that felony punishable by up to 10 years and or $15,000 or 3 times the value of the property that was taken. I'm told today you're going to plead no contest to that offense as it's charged. Now, when you do so and you plead no contest, assuming I accept that plea and I find you guilty, you're going to be waiving certain rights that you would otherwise have at a trial, because you won't have a trial now. Anyways, I'm holding up a piece of paper that'll look that Mr. Harrison gave me in chambers, and it appears to have your signature at the bottom. Is that your signature?
Yes, sir.
Now, did you read through these rights before signing?
Yes, sir.
And did you understand those rights that were listed there?
I do, yes, sir.
Okay. And even more importantly, do you understand that if you plead no contest and then I end up accepting that plea, you will be waiving these rights as they apply to this particular case?
I do, sir, yes.
So you'll be given up the right to claim that the plea today was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to get you to enter this plea that no one's told me about today? Now, Mr. Harrison's probably talked about sentencing with you to give you an idea of what the exposure is. Even though I told you the maximum punishment is up to 10 years and so forth, he's probably talked to you about something called the Michigan Sentencing Guidelines. I wanted to tell you that those guidelines are not mandatory. The court must consider them. And there are some limitations on or requirements that the court must follow based upon how those guidelines are scored, but there is still some discretion within the court, which is me, when it comes to sentencing. So I highlight again, the guidelines are not mandatory, but they are a very important tool, and there are certain requirements that limit what I can and can't do for sentencing. But it's within the court's discretion. Do you understand? Now, if I accept this plea, we'll probably continue on bond here and have you come back in about a month or so, but we'll talk about that in just a moment. Before I ask you how you finally plead here, do you have any questions? Now, again, I anticipate the plea to be no contest. I highlight that. I'm not trying to tell you what to say, but sometimes when I turn even in a no contest, people have seen it way too much on TV, they say guilty. So again, in this particular case, on that single charge, Ms. Bottoms, how do you plead?
No contest.
Thank you. Now, before we entered the courtroom, the court was given this exhibit by counsel. It's listed here now as or marked as People's Proposed Exhibit number 1. It is includes a couple different reports. I should call them an original and some supplemental reports. Just a second. All right. This exhibit is a Michigan State Police Department report bearing the incident number of 71-3487-24. It consists of an original incident report that is 4 pages. Then it includes a supplement number 1 that consists of 3 pages, and it also consists of, see, supplement 2, not that I need it, but it includes supplement number 3. And supplement number 3 has 2 pages. And then behind it, there are some other attached exhibits that appear to go along with that supplement. Mr. Carnes, are you asking the court to accept these exhibits totaled together as People's Exhibit 1?
Yes.
Mr. Harrison, any objection?
None whatsoever, Your Honor.
All right, thank you. People's Proposed Exhibit Number 1 is hereby admitted, as I described a moment ago on the record. Again, as I've already stated, the court did go through this thoroughly before taking the bench today. I'm going to highlight the report describing the incident with a date range between possibly March 1st of 2024 through potentially October 16th of 2024. Looks like the report was actually made the day before on October 15th of 2024. I'll note that it covers the venue of Club Cadillac, which the court notes, even according to the report, is a 501c3 connected to Northern Lakes Community Mental Health, and that it's located here in part of the city of Cadillac out there in Herring Township here in Wexford County. I will also note that it describes here that Ms. Bottoms was not only a member of that program, but then later became a treasurer for the program. I'll note that it appears here that the suspicions rose back in July and September of 2024. An investigation or internal investigation was conducted. I'll note that inside the supplement number 1, it describes the state of the investigation. Like the events allegedly did begin in March of 2024. I see the amount that's listed on page 2 of 3 in supplement 1 actually adds, if added together and we're all totaled, would be approximately $73,970.59. Even more importantly, I'll also note that on page 3 of that supplement number 1, there are statements that the court does now consider a confession. Therefore, oh, by the way, and I've also looked at the portions that were in supplement number 3. Mr. Carnes, do you believe the interest of justice did not require the defendant to state a factual basis based upon potential civil liability?
Yes, Your Honor.
Do you believe that this report contains adequate information and evidence to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court is in compliance with Ms. Kroll 6.302?
Yes, Your Honor.
Mr. Harrison, do you agree with all those statements?
I do, sir.
Great, thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained inside the exhibit, People's Exhibit number 1, which again was admitted by this court into evidence, satisfies the elements of the charged offense. The court also finds that the interests of justice, as stated earlier on the record, do not require the defendant to recite a factual basis. Therefore, the no contest plea is accepted. The defendant is found guilty of count 1. Ms. Bottoms, this case will now be set for sentencing. That sentencing will occur in about 4, maybe 5 weeks. We do them every Monday morning. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. Now, that report will describe the offense, describe the pretrial agreement, give me information about you, maybe include any prior criminal history if there is any. It will also include a score to the guidelines, which I've already told you were not mandatory, and it will make a recommendation as a sentence. Please keep in mind it is only a recommendation. I'm quite sure if you ask all of them downstairs in that office or everyone else here in this courtroom, it is merely a recommendation, as I'm very independent and I will make my own decision. All right, now when we come back for sentencing, you'll probably hear maybe some from victim statements. I just want you to be prepared from that. Between now and then, this report, it's going to be prepared. There are 3 steps that involve you. When you leave this courtroom, you're going to go downstairs to the Michigan Department of Corrections office. They're also known as the probation or parole office. Now, if you take the elevator all the way down, or take the steps, they end at the same spot. You'll do a button hook to the right, go down a little ramp where you see a bunch of soldiers in black and white fighting over World War I. Probably one of the battles of the Marne, but anyways, won't go into history. You walk down past that sign, go through the door at the end of the hallway, second door on the left is their office. They're going to give you a packet. You're going to open it up, follow the instructions, complete all the information that's asked on it. Turn it in. They'll also schedule an interview with you, and you have the right to have Mr. Harrison present during the time of that interview. And number 3, Mr. Harris is going to have to meet with you prior to coming back to court because he's got to go over that report with you because you each have to make sure it's complete and accurate before the court gives a sentence on it. Do you understand? You have any questions about what we have done today? You have any questions about what you got to do when you leave the courtroom today? And we should be back in about 4 or 5 weeks. Now, Mr. Carnes has got a curious look on his face. Is there anything else over there?
I'm looking at a different file.
He's not even paying attention to me. I hereby hope, no, never mind. No contempt today. Anything further from you today, Mr. Harris?
Nothing further, Your Honor.
Ms. Bottoms, we'll see you in a couple weeks. Anything from you? Thank you. Your bond continues to remain. I'm sorry, we are adjourned. Thank you. Carnes, your exhibit, sir. Thank you. All right, let's see if we
Do you
can, yeah.
want me
let-
to see if they want to break out?